Hi, Tony DeWitt here. I'm a retired Missouri appellate attorney, and I like to make the law make sense. So if you'd like for the law to make sense, stay tuned. There are people who will tell you that the closing argument is the most important part of a trial. It isn't. What is the most important part of a trial is everything that's done up to and including the first day of trial, especially jury selection. Jury selection is indeed the most important part of any trial, whether it's a criminal trial or a civil trial. Evidence is the second most important part. Getting the evidence in, making sure you get in your evidence and you keep out the evidence from the other side that will hurt you, to the extent that you can, and to the extent that you can't, that you have the ability to explain it. Although a good friend of mine said that when you're explaining, you're losing, and I think there's some truth to that. But what closing argument is the last best chance for you to put your spin on the evidence that's been presented. And particularly in a high-profile murder case where you're on court TV, for heaven's sakes, among other places, the idea that you have the opportunity now to get up in front of not only this jury, but all the other people who are watching this trial across the country and review your case and put the information out there so that the jury makes the right decision in your mind, it puts a huge burden on the lawyer who is doing the closing argument. And the lawyer who did the closing argument in this case and who handled a lot of the important questioning in this case, I think did a B-plus job. It wasn't an A-plus job because it was, in my opinion, it wasn't well organized. But he did hit some highlights, and we're going to take a look at some of those highlights in this video. One of the things that happens before you get to closing argument is the jury's instructions are read, and then it's time for the attorneys to argue. So, of course, one of the first things they do is they go through the elements of everything. In this particular instance, in addition to doing the elements briefly, he talked about one of the instructions that talked about using common sense. And then, after that, he began to talk about the totality of the circumstances. Well, there's a reason for that, and the reason is that this is a circumstantial evidence case. So, when you have a circumstantial evidence case, what you have is a collection of facts that taken together are indicative of guilt of a particular person. But there is no smoking gun. There is no, I saw Colonel Custer with a poker in the living room. None of that. What you get is a collection of facts, and the facts have to be laid out and gone through so that the jury understands where all those facts lead. But in order to get the jury there, I think one of the most important things that the lawyer did here, that the prosecutor did, was talk about the totality of the circumstances. Let's listen in.
So now let's talk and focus on the totality of circumstances. That goes to all of that on that table, all the things that have been presented to you, showing how she hijacked his Facebook, showing how she impersonated him to his friends and family members through texts, Facebook messages, took all the efforts she possibly could to avoid anyone from starting to look. Now, you have heard various friends and family members talk about how over the course of 2.5, 3 years, they went looking for Michael. It wasn't a scenario where he talked to anybody on a daily basis, weekly basis. There were times that he would go and not visit and things of that. But he always responded. When people would reach out to him, he would respond. He wouldn't leave those messages unanswered. And when they did get any response after November 2015, every single person that talked to you about that said it was obviously different. It was not the way he would respond. Finally, when taking all of the circumstances, all of the evidence, and putting it all together, that's where the state is asking you to rely on your common sense. Because you can take any one piece of this puzzle and you can look at that and you can say, well, I mean, that's not an eyewitness that saw what happened. That's not a piece of DNA. Maybe that's not something that proves in and of itself that Laurie Shaver committed this murder. And we're not saying any one piece of evidence over there does that. We never have. We got up here, Mr. Buxman in opening was straightforward with what you were going to see. He told you there's not going to be a witness that's going to say Laurie Shaver did this, that I saw her do this. He told you what the forensic evidence was going to be. We put that up there so you could see it. But we also gave you the explanation of why, after someone is buried in the ground over multiple years and their body decomposes, the effects that that has on any sort of trace DNA evidence, any sort of trace fingerprint evidence. But we were upfront about that with you. We told you that's how it was going to be. But we are asking you to follow that judge's instruction and use your common sense in looking at all of this together. Because when you look at it all together, the conclusion is crystal clear.
Well, I thought he did a really good job with that. That's a B+ oral argument for a closing in terms of talking about the totality of the circumstances, because you don't have a video, you don't have a smoking gun, you don't have an eyewitness, you don't have forensics, you don't have bullets matching up to the gun that Laurie Shaver sold to somebody. You don't have everything that you need to have to make this an easy case, a slam dunk case, a case where the defendant would have been wise to simply plead guilty. This is one of those where, unfortunately, for the defense anyway, they have enough to get to the jury on the chain of evidence that links her to this crime, particularly things like, impersonating him on Facebook and on messages and in emails, and pointing out that people who received those didn't think that they were really from Mike. So now, because they don't have this, he argued the totality of circumstances. Now what's going to happen is the defense attorney is going to get up and talk about, hey, they don't have a video, they don't have a witness, they don't have forensics, they don't have DNA, they don't have any of this stuff. And basically, because my client buried this guy in the ground and destroyed all the physical evidence, you got to let her go. And I think part of what he does here is very, very effective in terms of what they don't have. But it also tends to ignore what they do have. So watch this little portion of his closing argument, and I think it's a B+ closing argument. I would give him that. I thought he's doing a reasonably good job here in the oral argument portion. I just don't think that he did very well in terms of cross-examining many of these witnesses. But let's take a listen to this portion of his closing argument.
Or she's sleeping around. Why did we have to hear that testimony to disparage my client? To think they're going to get emotional impact out of you? Is that relevant to this cause? Is it probative to a material fact that you have to decide? No. It's disparagement for the attempt to pull an emotional result out of you to fill in a verdict form. I told y'all at the beginning in my Vordi, the state has a responsibility to seek justice. And I said, what is the state seeking here? They're seeking a verdict. That's what it is. So most of what you heard, if not all of what you heard, is an emotional ploy for you to go back there and out of anger for Laurie Shaver, fill in a verdict form for the state. That's what's going on. That's what you've heard this week. second-degree murder. Mr. Camuccio went over the elements, so I'll briefly touch on it again. The defendant's dead. Yeah, we know he's dead. Okay? The death was caused by the criminal act of Laurie Lee Shaver. Okay. Has any single witness taken the stand and shown you one piece of evidence that established Laurie Lee Shaver killed Michael Shaver? Zero. Zero. Case over. Period. What they've done is brought in a bunch of digital data after the fact, after the event, and said, well, she tried to cover it up, or she didn't want to talk to this person, or she didn't want to talk to that person. Well, there's a good reason she probably didn't want to talk to numerous of these people, but a lot of it probably didn't have a darn thing to deal with the death of Michael Shaver. 3, there was an unlawful killing, an act eminently dangerous to another, demonstrating a depraved mind, without regard for human life. Okay. Has anybody established a depraved mind? No. Without regard for human life? No. Laurie Shaver was in her house when she was attacked. That's what happened. Did the state offer any evidence on causation, where this event occurred, how it occurred, any different than what the defendant and her daughter testified to? No. No. In fact, you may remember Tamara Dale. She gets up there, and I talked to her about it. And I said, you don't have any DNA, do you? No. You don't have any prints, do you? No. You have nothing in the scene in the house to suggest any activity, do you? No. You don't have anything in a gravesite, do you? No. You don't have any prints in there? No. You don't have any DNA in there, do you? No. You don't have any gun that links Laurie Shaver to the crime, do you? No. You don't have any confession, do you?
So he's playing to his strengths, right? They don't have a lot of the evidence that they probably would like to have in order to get this conviction. And he does talk about the fact that the daughter came in and testified and said that it was a she done it. Of course, it's a little difficult to credit that given that all of the other things that went on at the same time that were designed to obfuscate the entire murder and keep anybody from discovering it. And when you put somebody 3 or 4 feet underground and cover him up with concrete, that's a pretty good indication that, maybe you're playing fast and loose with the truth. So the prosecutor then gets the final word. And let's listen to his statement at the end of all of the closing arguments.
This didn't happen the way Laurie and Isabel said. In talking about the 2014 incident, Mr. Wiggs talks about how he went after Wilma Nicholas, and he pointed out that, the state prosecuted her or him, and you only got one side of the story. But that completely ignores the fact that Katina Vasquez, Laurie's friend, came in and said, you know what? Laurie told me she fabricated that. That's not the way it happened. She was the aggressor. She threw that flower vase and broke the slide glass door. She hit her husband over the head. And when Mike was saying that he was trying to basically grab her, to control her, to stop her from doing these things, that was true. That's her friend saying that. The timeline is that Michael Shaver, as Laurie said, is not a missing person. He's no longer walking the face of the earth. And he has been that way since before November 10th, of 2015, when all indications of him and his life are gone. No bank activity, no phone activity, no contact with family, no contact with friends, no contact with work. Wasn't at the hangar where she said, wasn't in Georgia where she said. He's dead because she killed him. And then she made up this May 2016 story to distract. That's pure and simple what we have. If there is absolutely no evidence consistent with that May 2016 story, ask yourself why. And it's because she killed him in November. And because of that, she's guilty of second-degree murder with a firearm. I ask that you return the only verdict consistent with the law, the evidence, and justice, and that is guilty of second-degree murder with a firearm. She possessed that firearm. She discharged that firearm, and she caused great bodily harm or death. Thank you.
If you have a good jury, they have good BS detectors, and they can tell a load of baloney pretty quickly. And so when you give them a set of facts that, and a logical progression that point to one inescapable conclusion, most of the time that's the conclusion they're going to reach. And when you get up and you point out that in their in the presentation of the prosecution, they didn't dot a few I's and cross a few T's, and by the way, look over there, squirrel, you minimize your effectiveness at getting a verdict that is favorable to your client. Now again, the defense counsel here did not have a good case, and that's not his fault. No defense lawyer can file a timely motion to change the facts. If you have a bad case and you do your best, you can look back and say, well, I did everything I could. And I think this gentleman did everything that he could. And while I might have a few stylistic issues with how he did things, he put up a good defense. He certainly put up a constitutionally sufficient defense for this client. And that's really all you can hope for if you are a defendant, is to get somebody who can make the case for you that, the facts and evidence allow them to make. And I felt like the prosecution's use of totality of the circumstances worked really well with his defense of, but what about this? Yeah, but what about that? Yeah, what about the daughter who is strictly under the control of the mom, testifying that she did it because nobody's going to prosecute an 8-year-old for murder? Again, it's just one of those things that I think a jury with common sense sort of thinks about and goes, yeah, no. An 8-year-old would have gone around and told somebody. An 8-year-old would eventually have broken down and told someone that she did this thing, and as a result, this is sort of a ex post facto determination that is foisted on the girl by her mom. And as a result, as you probably well know at this point, the verdict came back fairly quickly, and they convicted her of second-degree murder. I think that's a just verdict in this case. I also think that if you get a very critical appellate panel, they might very well conclude that there was insufficient evidence of causation, because there wasn't a great deal of evidence that anything Laurie did personally caused this death. It's all circumstantial. So, with a right appellate panel, she might very well get a different result. But that's going to be many months down the road. That's what I have for you today. So thank you very much for watching. I hope you've enjoyed part 3 about the closings. If you have any questions, drop them in the comments down below, or you can email me at the address above. If you have the opportunity today, go out of your way, do something kind for someone, and then come on back down here tomorrow. Join me at the beach, and we'll talk about something else, and maybe this time it won't be murder. I shouldn't have to say this, but you don't seek legal advice from a guy down at the beach. You seek it from a lawyer in a lawyer's office, where there are people running around in suits and secretaries and all kinds of other people. I'm just a YouTuber. I'm a retired attorney at this point. And although I retain my license to practice in the state of Missouri, I am not here dispensing legal advice. I'm just offering general content on the law. So please don't take anything I say here as legal advice, and if you need legal advice, see a lawyer in your jurisdiction. And keep in mind that if you don't have money for a lawyer, if there isn't a legal aid society that can help you, often law schools have clinics where student lawyers can represent you in court, and often they do an awesome job. And here are some videos that YouTube thinks you may enjoy.